Okay, so 730 is mental disease or defect excluding fitness to proceed. Okay, so 73010 is all definitions. So I'm just going to go through them real quick. An incapacitated person is a person who, as a result of mental disease or defect, lacks the capacity to understand the proceedings against him or to assist in his own defense. An order of examination directs the detention of a person for the purpose of determining if he is an incapacitated person, and that is a maximum of 30 days, if you know from 330. Commissioner means the State Commissioner of Mental Health or the State Commissioner of Mental Retardation and Developmental Disabilities. The Director means the Director of one state hospital operated by an Office of Mental Health or Director of Developmental Center operated by an Office of Mental Retardation and Developmental Disabilities. Or 2, Director of Approved Governmental Hospital. Or 3, the Director of Community Mental Health Services. A qualified psychiatrist means 1, a diplomat of an American Board of Psychiatry and Neurology or eligible to be certified by the board. Or 2, certified by American Osteopathic Board of Neurology and Psychiatry or eligible to be certified by that board. If you already did Mental Hygiene Law Article 9, you will know that that definition of the qualified psychiatrist is the same. Just as a note. Certified psychologist means the person registered as a certified psychologist. Psychiatric examination means qualified psychiatrist or certified psychologist designated by the director to examine the defendant pursuant to the order of the examination. An examination report, the form is promulgated by the state administrator and commissioner, means a report made by a psychiatric examiner, not 2, a psychiatric examiner on whether the defendant is an incapacitated person. In Mental Hygiene Law, Article 9, it had to be 2 psychiatric examiners. An appropriate institution, hospital operated by 1, the Office of Mental Health or whatever that whole thing is, developmental center operated by the Office of People with Developmental Disabilities, or 2, other qualified and licensed hospital by the Department of Health. 73020, fitness to proceed, generally. 1, after an order of examination is issued by the court, the director must designate now 2 qualified psychiatric examiners to examine the defendant to determine if he is an incapacitated person. 2 qualified psychiatric examiners. There's 2 in Mental Hygiene Law, Article 9. Just trying to make things make sense here. 2, if the defendant is at liberty and upon request of the director, the court may direct that the defendant be confined in a hospital under the examination until the examination is completed. That again, Mental Hygiene Law, Article 9. 3, if the defendant is in custody, examination shall be at a place of custody unless the director determines that the hospital confinement is necessary for an effective examination. 4, hospital confinement pursuant to an order of examination shall be for initial period not exceeding 30 days. Can be extended by the court for an additional period not exceeding 30 days. So hospital confinement, examination order, 30 days, extended 30 days. Each psychiatric examiner must prepare an examination report. If the 2 reports are not in agreement, the director must designate another psychiatric examiner. Upon receipt of the reports from the director, the court must give a copy to the defendant and the DA. This is making so much sense now, why they have this on the test. I just don't know why I didn't see it before. 6, statements made by the defendant for the purpose of examination are not admissible in the criminal action in any issue other than his mental condition. Psychiatric examiners are entitled to $50 for each examination and $50 for each court hearing for a total not exceeding $200. So $50 for the examination, $50 for a hearing, not to exceed $200, and they're entitled to traveling fees. If the examiner is a New York State employee, they shall only be entitled to traveling expenses. Of course, we get screwed. Okay, Also, fee if he works outside hours of employment or outside the county. Okay, 73030. Whoa, we do this too in the court, so this is good to know. An order of examination. 1. Generally, a court issues an order of examination after arraignment, other than a felony, when it believes that the defendant may be an incapacitated person. 2. If the court is not satisfied with the examination reports showing that the defendant is not incapacitated, it may order that the defendant be examined by a different psychiatric examiner. Otherwise, the action will proceed. 3. If reports show incapacity, the court may conduct a hearing on its own motion and must conduct a hearing upon the motion of the defendant or the DA. So must conduct a hearing if the DA or the defendant make the motion, but they may do it if they make the motion, the court. 4. If the reports regarding incapacity or danger or dangerousness are not in agreement, the court must conduct a hearing to determine the issue of capacity or dangerousness.